May it please the court, my lord, I appear for the state together with my colleagues Mr. Singh and Mr. Deploy. May it please the court.
Thank you, Mr. Dana.
My lord, together with Mr. Thales and Mr. Kulu, on the instructions of Mr. the two senior attorneys who appear for the first accused.
Thank you, Mr. Masuku.
Thank you, my lord. Mr. Jackson, I appear on behalf of the second accused, Herbert Smith and Friedland attorneys.
Thank you, Mr. Roo. Yes, I think the first order of business, Mr. Masuku, deals with the question of the representation of Mr. Zuma.
Yes, I've placed on record that we now instructed by Mr.
Yes,
with the senior attorneys for Mr. Zuma.
Somebody here from the erstwhile attorneys and counsel?
Mr. Mabuza is present.
Mr. Mabuza is present.
And may he be excused?
Well, let me just deal with that firstly. This matter was adjourned on the 23rd of February this year, when it was certified as trial ready in accordance with the Judge President's pre-trial criminal court hearings directive, and the matter was postponed by agreement to the 17th of May, which is today, until the 20th of June 2021, and then days thereafter as and if required. That's correct, is it, Mr. Masuku?
That's probably correct, madam.
Yes, and your position today is that you are here to take over from Mabuza attorneys, and that you are ready to proceed and are available for that period.
Yes, I am.
Yes. Well, on that basis, then I can't see any prejudice to the accused. Any reason why leave to withdraw should not be granted to Mabuza attorneys, Mr. Dana?
My lord, the state is in the hands of the court and has no objection. We do place on record, however, that it's unfortunate that the instructions seem to have come very close to the start of the trial.
Yes.
And we would not wish that to prejudice the conduct of the trial
Yes.
in any way.
Yes, but from what I gather, it won't prejudice the state, nor, importantly, Mr. Zuma or the second accused,
Indeed,
because Mr. Masuku is in a position to proceed.
Indeed, my lord. We take
Yes.
note of that.
It's not as though he says he needs more time
No.
for preparation. There are other things that he wishes to raise.
We note that with appreciation, my lord.
Yes, thank you. Mr. Roo, anything you wish to add?
We have nothing to add, thank you.
Yes, thank you, Mr. Mabuza. Leave is then formally granted for you to withdraw as the attorneys of Mr. Zuma. Thank you, and you may be excused.
My lord, then I beg leave of the court for me to be on my feet, as this is now formally the start of the trial. The court will be aware that the matter was postponed until today for the trial to start. Might I just begin by mentioning that we had discussions with your lordship in chambers, where the various issues, procedural issues relating to the start of the trial were discussed, and it falls to the state to decide how to proceed from this point onwards. I might just put on record, as we indicated to your lordship in chambers, that my learned friend Mr. Masuku informed me last week that they intended bringing, on behalf of Mr. Zuma, an application for me as the prosecutor, the lead prosecutor, together, who's as the lead prosecutor, for me to be recused or to recuse myself. And we were promised that papers would come only today. I haven't seen them yet, my lord. I've been told about them. The position now, as I understand from my learned friend, Mr. Masuku, is that there is a substantial plea, special plea, in terms of section 106(1)(h) of the Criminal Procedure Act. For your convenience, my lord, we do have facilities which enable documentary evidence to be displayed to the court, and this will be the first opportunity for us to show the effect of such electronic displays. So we now are all able to see section 106(1)(h), which is a plea that the prosecutor has no title to prosecute. That is what my learned friend informs me, although, as I say, I haven't yet seen the papers. Furthermore, my learned friend, and then I might just point out to the court that in terms of section 106.3, we could just scroll down to that, an accused shall give reasonable notice to the prosecution of his intention to plead, a plea other than the plea of guilty. So in short, the accused has to give reasonable notice to us, the prosecution, about the special plea in terms of section 106.1h. And I'm very appreciative that my learned friend has today now, in effect, given us such notice. The trouble is, my Lord, as we indicated, that we don't yet have the plea. I'm informed by my learned friend that it is supported by substantial papers, including evidence under oath, if I understand him correctly. And I'm informed that that evidence under oath, the affidavit, is not yet ready. It hasn't been signed because there's certain annexures outstanding. My learned friend has explained the position to me. So in the circumstances, my Lord, as we indicated, it would not be in the best interests to deal with this matter piecemeal, put the charge now, and then deal with the 106.1h application only at some later stage, once the state has been able to establish what the contents of the 106.1h plea is, and to decide how to respond to it. It seems inevitable, given the information that my learned friend has given me, it seems inevitable that there will be some delay, because we need to consider the papers which have not been given to us, we need to consider our position, and no doubt we would have to reply under oath from one or two or more people within the NPA or otherwise to enable the court properly to appraise the plea. So all of that led us, my Lord, in chambers, to decide that it is inevitable that this matter has to be postponed, to allow the state to read my learned friend's plea and to decide how to respond. And so,
Mr. Dana, sorry if I may interrupt you. As I understand the position then, this is not an application for your recusal. What is being raised in the context of section 106.1h as a plea.
So I'm informed by my learned friend, my Lord.
Yes.
I can't...
You haven't seen it yet.
Yes.
It just occurred to me, walking down to court, and it's not something that I've raised, and if you need time to reflect on it, and that invitation is extended to all the counsel, then please tell me so. Section 106 deals with the pleas that may be entered by an accused person, guilty, not guilty, etc. And then also the situation we're dealing with at the moment. We had a brief discussion at the level of practicality, not to have to return to court every few days, but to give you an opportunity, firstly, for them to file their affidavit with all the annexures, and you to reflect and to consider it. But it just occurred to me, is there something to consider for the purposes of section 106.1h until it's actually been pleaded? It might be a case of formalism, I'm not sure. If it was an application for your recusal, then it would be brought on notice, an application with exchange of affidavits to follow thereafter. But is it procedurally correct to deal with this under the auspices of 106.1h until it's actually been pleaded? Or are we going to be faced with a situation that the affidavit detailing the grounds for the plea will be prepared, then submitted to you? I think we said Wednesday, they should be ready, and that a plea be recorded on that day, of which the affidavit is simply providing the detail of what that plea entails. You understand what I'm trying to communicate?
Yes, my
As
Lord.
to whether one can have this and prepare, consider it, and file answering affidavits and the like with a view to adjudicating it, when in fact it hasn't actually been entered as a plea.
I understand your Lordship's point, and I think it all turns around the requirement in terms of section 106.3 that the state has to be given notice. And we have not been given notice. Today is the first time we've heard of it. We haven't yet seen it, so I would presume it is sensible to interpret that notice as notice of the substantial content of the plea in terms of section 106.3. Without that, we don't have notice, and so we can't deal with such a plea. And I submit that it wouldn't make sense, certainly now, to take the plea now, because we need to consider our position as to what attitude we're going to take. And we can only do that once we know the content of it.
Can I summarize the position then as follows, if it's accurate? If not, please stop me. That the affidavit will be filed on behalf of the first accused, raising the grounds which will found a plea in terms of section 106.1H by Wednesday. And that you as the state, you are prepared then to accept that as the notice and to file your answering affidavits if required, or take whatever action, consider your stance in regard thereto, although it hasn't been formally entered as a plea, on the basis that you will return to court with the, well, hopefully the full exchange of affidavits on, I think we said the 26th, was it?
26th, yes, madam.
And then that the plea be recorded on that day. Because I don't think it will be correct to hear argument on what might be contained in the affidavits unless it's formally entered as a plea.
Well, provisionally, I think that would be a very sensible approach. I would agree with your lordship with respect. And with one proviso, that unless there's something that we don't know in the 106 draft or in the 106 affidavit which you are given, which might change our position. I hope it doesn't. I imagine it wouldn't. But I think the court's suggestion is sensible and correct.
Yes, the affidavit is going to deal with the grounds for advancing the plea in section 106.1H.
Yes.
Nothing more, nothing less, as I understand it.
Indeed, as we understand it, yes.
Yes. Let me just hear from Mr. Masuku, that procedure that I outlined now, the formality and etc. Do you have any submissions in regard thereto? Do you agree with what I suggested?
We agree with your lordship. It will accommodate the view that we had, that this is a plea which comes immediately after charges have been read to the accused, and the accused pleads this particular plea. So we accept that in the circumstances of the notice requirement, your suggestion would be appropriate, as long as we are going to have an opportunity to enter this as an opportunity to formally enter this as a plea.
Yes.
In the next appearance that is scheduled. I think we say 26th of.
Yes, you've indicated to me, and I hope I'm not talking out of turn, that you have the not guilty plea ready.
Yes.
So to speak.
Yes, we do.
But I don't think it's prudent that we deal with the plea procedure piecemeal. You know, that we take a not guilty plea today and then deal with a plea in terms of section 106.1H on another day. So as I envisage the procedure, you will file your affidavit, provide it to Mr. Downer, the state, by Wednesday this week, the 19th.
Yes, we will.
That will then satisfy the notice requirement.
Yes.
And they've accepted that as the state. They are prepared then to consider their position in regard thereto. Filing of affidavits if one is required, or if no affidavit is required, then to take what other steps they might be advised. We will then return, hopefully on the 26th, well, not hopefully, we will return on the 26th of May this year. On that day, the affidavits might all have been filed, or they might not have been filed. We'll have to see. But then, at least by then, the state would have had notice in terms of section 106.1H. And the 26th of May can then be used, if nothing else, for taking the plea.
That's correct.
Are you happy with that arrangement?
I'm happy with that, my lord.
So the 26th will be for the plea. On that day, the indictment will be put. We'll have your plea of not guilty. And by then, the affidavit raising the 106.1H plea would also be available.
That's more
so
sensible.
The plea can be done properly.
That's correct. We're happy with that.
All right?
Yes, my juniors are all shaking their heads this way. That means they're happy as well.
Oh, I'm glad to see that. All right. Thank you. Anything else you wish to add about the procedure?
Nothing else, my lord.
Thank you. Mr. Roo? from the
Nothing
anything you wish to add?
It just makes good sense, man.
Yes.
Might I just ask my learned friend, I think we forgot about this, if he's going to give me the 106, 1H plea, to also give us the 115, so you can consider the two together. I don't know if you
Mr. Masuka, that
I'm
seems...
sure you can ask me when.
Yeah, but it seems that's just... it's appropriate that it be done like that.
Yeah, no problem.
Because, yeah, you can provide him with a statement, but the formal plea will be recorded on the 26th.
We're happy with that.
All right.
Thank you.
Anything else in regard to that issue then, Mr. Dana?
No, my lord.
So it's envisaged then that the trial will be adjourned to the 26th of May 2021 for the purpose of what we've discussed now.
As it pleases the court, my lord.
Just before I attend to that, I've also previously issued directions regulating the position for the filming of these proceedings to ENCA, but that only really covered what I called the preliminary issue of the representation of Mr. Zuma, which has now come and gone. As we're now entering the trial proper, there is a new permission and directions for the filming of proceedings, which I've made available to counsel when they saw me in chambers. And I understood, Mr. Downing, that there's no objection from the state to what I've proposed. Is that right?
We're in full agreement, my lord.
And likewise, Mr. Masuka, for accused number one?
Likewise.
Yes. I'll just read it into the record. It's as follows: permission and directions for the filming of proceedings. 1. ENCA has granted permission to be the pool feed provider for radio, online and television stations in the trial of S versus Zuma and another. To that end, it is permitted to A. broadcast the audio recording of the entire trial in live transmissions, delayed broadcasts, and stroke or extracts of the proceedings. B. audio visually record the trial, but excluding the filming of any witness who objects to being filmed. Witnesses who object to being filmed will have their wishes respected. However, a full audio of the evidence will be broadcast, as well as audio visuals of the legal practitioners and the judge, even when the objecting witnesses give evidence. It will be incumbent on the counsel calling a witness to indicate to the court at the outset should the witness object to being filmed. The aforesaid permission will be subject to the following specific directions. 1. ENCA is permitted to install 4 video cameras to record and stroke or broadcast the proceedings. 2. The video camera shall be set up by not later than 15 minutes before the commencement of proceedings every day. 3. Microphones may be installed next to the judge, legal representatives, and on the witness stand. 4. All cables must be taped down to avoid any interruptions. 5. The video cameras shall be stationary, erected on tripods, not be attended by any person, but controlled remotely from a technical site outside the courtroom. In the event of a technical challenge, 3 operators may be deployed to replace the remote controlled cameras. 6. The video camera shall be located in such positions as the court may from time to time direct. 7. The video camera shall be located and operated discreetly to cause as little intrusion in the proceedings of the court as possible. 8. ENCA may record and take video footage in court for 10 minutes before the commencement of court and after the adjournment of proceedings each day. 2. The parties may approach the court for any variation or amendment of this order should the need arise. 3. The aforesaid permission and directions may be revoked or varied at any stage in the sole discretion of the trial judge. That's just for general notification, and also that witnesses who might be here now appreciate that that is the basis upon which the trial will proceed.
Pledge to the court.
Thank you.
My lord, on a housekeeping note, might we propose that we start an exhibit numbering system, and that this might be the first exhibit of what might prove a long trial?
Yes.
So if we could start with Exhibit A, that would kick off proceedings.
This permission to televise will then be Exhibit A. Thank you.
Thank you, my lord. Then from the state, I think the last aspect is, as we mentioned in chambers, because of the uncertainty about whether this trial would begin, the state has always been ready to begin. we deemed it prudent to have our first witness here at court in case we could begin with her. And I would ask the court then to excuse her. She is Minister Patricia de Lille, who's kindly consented to come and be ready to testify. I would ask the court to warn her to return, or when we ask her so to return. I've discussed the position with her, and she has so agreed. So we don't ask the court to warn her for a specific date, but we ask the court to thank her and to request her to return when the state can use her, can present her evidence. Mrs. de Lille is in court on the back of your lordship's right.
Yes, I can see her there.
Thank you.
Mr. de Lille, thank you. Minister de Lille, thank you for attending today. Unfortunately, the matter cannot proceed because of issues that have been raised. I understand from Mr. Dana that you'll be requested to return, and you only need to return as and when the request is made by the state to that effect. But for the present, you are excused. Thank you.
I'm indebted to the court, my lord.
Anything else, Mr. Dana? Sorry.
Yeah, I think that's the complete list from the state side, my lord.
Yes, I've discussed court times with counsel as well. I'm not going to place that on record, but you know what it will be. Sorry, Mr. Masuku, I interrupted you.
Yes, my lord, just to also place it on record that Mr. Zuma is ready to proceed with the trial.
Thank
He's
you.
always been ready to proceed with the trial, and your lordship will see he's in the box. And to the extent that it's necessary, you would want a witness in the box to return on a specific date for the trial. We think it's important that it is clear to the state that Mr. Zuma is ready, has always been ready, and that it should never be regarded that our plea that we intend to raise is a sign that we're not ready.
Yes.
We are ready.
Yes. No, I think the important point that you make is that he's ready to proceed, and you have now raised this plea in terms of Section 106(1)(h), and it is being accommodated. So I don't think there are any negative inferences to be drawn from that.
I hope not. But
Yes.
I'm pleased with your interpretation of it.
Yes. Well, that's on the facts available to me at the moment. I'm happy to take note of what you've submitted.
I appreciate it.
And I appreciate that Mr. Zuma has communicated that to me. Thank you.
Just for completeness of the record, my lord, Thales is ready to proceed today, whatever day. We're ready with the plea explanation, the admissions, and to proceed with trial whenever that date is.
Yes. Well, the matter is going to be adjourned to the 26th
Yes.
of May for plea to be
Yes.
recorded.
We'll be ready.
Yes. Very well. Is that everything then? Mr. Wasuka, anything further? Mr. Roo, nothing else?
From the
Yes.
state side, that is the role, my lord.
Yes. This trial is then adjourned to the 26th of May 2021, back here in Pietermaritzburg in this courtroom, and the accused are warned to be present on that day, and as previously discussed, it's contemplated that on that day the plea will be recorded.
As the court pleases.
That is the court.
Yes, thank you. Court will rise.